Morning, everyone, and welcome. Thanks for joining us today. My name is Zain, and I work as a consultant on the B&G program here at the Planning Advisory Service. This session is part of a series of events the PAS team is putting together to support the implementation of B&G within local government. For B&G practitioners who work for a local council, if you haven't already, you can join the PAS B&G forum through our website to gain early access to future events and resources. For today's session, we will be hearing from Defra's Conservation Covenant policy team on the current state of play regarding the responsible body designation and best practice regarding responsible body applications. This session will also include presentations on becoming and being a responsible body from RSK Biocensus and Staffordshire Wildlife Trust. Please note there will be a Q&A following each of the presentations delivered by the responsible bodies, with an additional Q&A for the policy team towards the end of the session. If you have any questions, please use the Slido link. I will be adding it now to the chat. I haven't already gained access. It's in the chat now. This event is also being recorded and will be published and shared on YouTube following the event, so feel free to switch off your cameras and please ensure your mic is switched off during the presentations. Thank you. Over to you, Tim.
Thanks, Zain, and welcome everybody, and thanks to the PAS for supporting this event for us, and also thanks to RSK and Staffordshire Wildlife Trust for agreeing to come and present today on their experiences so far of becoming a responsible body. If we pop onto the next slide, Jane, I'll just take us through some quick aims for the day. I'm Tim Andrews and I'm the team leader in Defra for Conservation Covenants. So my team is charged both with providing the Secretary of State assurance that the responsible bodies that we're proposing to him are going to be responsible in the long term. It's been quite a complicated and difficult process. Responsible bodies unusually are not going to be monitored much by government, and so the assurance that the Secretary of State might want that they're going to act responsibly and do their job well is largely front-loaded. Hence, what is quite a complex, really, application process where we require quite a bit of evidence. But that's the reason, really. Once up and running, responsible bodies will largely operate relatively independently of government. Today, I wanted to just provide a little bit of an update on where we are with responsible bodies. Unfortunately, Jane, I'm not seeing my slide. Oh, it's okay. I can move it forward. That's fine. So where we are to date is that so far we've received about 47 applications to become a responsible body. So far, 21 have been designated. The good news is that we heard yesterday that another 3 responsible bodies have been passed the senior civil servants that are responsible for agreeing their designation. So we should have them up on the website in the next week or so. So we'll be up to 24, which is good news. And we're still processing another 20 or so applications. If you're on the call today and we've asked you to provide a bit more evidence, a bit of a nudge, if you've applied, if you're having any difficulties in terms of compiling that evidence, just email us on the email list at the end of the slide packs today. We're always happy to talk to applicants and try and walk them through where there's uncertainty about the kinds of evidence we seek. And hopefully today, Jane and Sarah and my team will walk you through some further advice and information on what a complete application looks like and some pitfalls in applying that you could possibly try and avoid. In terms of BNG, one of the key uses for conservation covenants, we've got 40 BNG game sites now registered, more in the pipeline. So that marketplace is beginning to become established. And indeed, certainly one of our presenters today in RSK have been quite active in that marketplace. So that's beginning to develop. What we're conscious of is, as well as we start thinking more about conservation covenants in practice, is that in fact there are lots more opportunities for conservation covenants to be used beyond the important use for BNG. So ecosystem services provision markets are going to become more and more established, and I think more and more exciting. And some of the models we're seeing emerge now, where we have responsible bodies working with landowners, but also third-party investors and brokers. So there's that potential there. And one of the things we wanted to do on the back of the presentations from RSK and Staff's Wildlife Trust today, was to try and encourage some thinking and some thoughts around what other opportunities there might exist so that we can realise the benefits of using conservation covenants as a tool to secure nature conservation in the long term. Some of the underlying thinking around covenants originally was that they would help move some of the funding for nature recovery in the long term from the public to the private sector. And I think some of the markets we're seeing emerge now will support that. And in doing that, we'd be interested to hear people's thoughts on some of the barriers to delivering those opportunities, where people have worked with landowners or where they have concerns about the use of covenants. It'd be great to identify them. And then if there's anything we can do within Defra to try and overcome some of those barriers or other things we can do to incentivise the use of covenants, we'd be keen to pursue those. And the last presentation today will deal with that last bullet on this slide, which is that we're keen to provide some support for those of you who are thinking or in the process of applying to become a responsible body. So hopefully that will be useful. And again, we'll take any questions around that. If you're on the call and your primary interest is in the first two sessions around the responsible bodies providing some sharing their experience a little bit, feel free to dial off for the last session. If you're not applying, it will be fairly detailed about the criteria to become a responsible body and what you might provide as evidence. So don't feel you need to stay on the call if that's not of interest to you. I think I've covered everything. We'll be aiming for about 15 minutes for a presentation, about 10 minutes discussion for each. We'll try and stick to time, but hopefully these three sessions will be helpful for people. That's all I wanted to say. With that, I'll move on to the next slide and invite Natalie to do her presentation from RSK, if that's okay. Thanks, guys.
Hi, thank you very much. I'm going to take control here. Can everybody see the slide still?
Can do, yes. Thanks,
on my screen. Yes. Okay. So my name is Natalie. I am the internal legal advisor for RSK Wilding and RSK Biocensus, and we were one of the first sort of chunk of responsible bodies that got approved as a private company, and I started work for RSK in May 2023, and it was just when sort of BNG was emerging and responsible bodies had been put forward in the Environment Act, but we hadn't had the secondary advice from Defra yet. So it was all very much, can we do this? I had to put forward a business case and work out really the risks of doing it. So my role started off a bit wider in terms of putting together the business case, along with my colleague Tim Graham, who I'm sorry today is on paternity leave and can't be here, but he's the ecologist behind it. So he's the ecological brain, I'm more of the legal brain. So just a bit about us. So RSK Biocensus are the responsible body, and that's a team of about 200 ecologists and do everything ranging from marine ecology to solar, the whole section. And RSK Wilding sits within RSK Biocensus as the specialist BNG team, and we're a team of about 18 people now. And the head of RSK Wilding wanted, was sort of saying, I think we want to become a responsible body. Can you please persuade me of how we're going to do this and what the merits are? Because essentially he wanted BNG to work. That's the kind of driving force behind it, is that BNG and the legal change in that and the change in the planning law is something that could transform nature recovery nationwide, really. So it was very exciting. And can we make it work? Do we want to ensure there are high standards across the board and that this works long term? So partly the reason why we're here today to say, please do apply to become a responsible body is that we do need more of them. We need more people to take on the demand that there currently is. My fear early on really was to think, if not enough people become a responsible body, then the whole sort of system is really going to not really work and could collapse at some point. We want people to take the opportunity. So I'll talk a little bit about our process, some of the things that we've learned and tips that we can give you on how to apply. So I'd say before applying, I think you really want to know why you want to do it. So our driving force really was to ensure that BNG worked. And we've got people in the team that have been working with CIEM to do ecological standards across the industry as well. We want to put forward a high standard and set a high standard of how this is going to run. So yeah, I started with the business case. There were lots of upfront questions really, such as, what's the upfront cost to becoming a responsible body versus the benefit and the profit. And at the time, very unknown. It was unknown market at the time, unknown costing. There was nobody to kind of measure your costs against. We didn't know how many people were going to come on board, so we spent a lot of time developing the concept and working out our internal procedures. With our application form, we were working on Defra's first application form. I believe it's been updated since, but the first application form, really, in all of the boxes we ticked see attached, and did our own big portfolio really of what we were planning, and that really was on the back of our business plan. And we probably put in, I would say we tried to put in more information than we thought we needed rather than less. So it was about sort of 30-40 pages of kind of, this is everything that we're thinking in terms of our internal process and procedures. And talking a lot about how we would manage the risk. How would we manage the risk of conflicts? How would we manage the risk of breaches? How would we deal with enforcement? All those things went into our business plan. So yeah, I'd say that there are a lot of considerations. I think that the main thing that you need to consider is, do you have the right expertise? So I was the first internal lawyer in RSK Wilding. We've now got 3. At the time, it was very new to me because my background wasn't BNG beforehand. It was more litigation. But in a way, it was good because at the time, nobody knew enough about BNG. So I was learning along with everybody else, which was nice. So we submitted our application in December 2023, and now we were approved in February 2024. So nearly a year of becoming a responsible body. Right at the beginning, I'd say it was a bit messier. Our processes were a bit messier. We wanted, really, before we had everything tied together, we wanted to know what other people wanted, what was the external market. So we started up these meetings called Coffee and Conservation Covenants, where twice a week people could sign on and say, we want to talk to a responsible body, we want to know what it is you're doing, we want to know what your costs are, what your process is. And that was actually just as helpful for us as it was for them, because we could then learn about what the market was, what were people interested in. And actually people were interested in conservation covenants across the board. We did have people looking at flood alleviation, we did have people looking at nutrient neutrality, but over time what we realised was there was this huge logjam for BNG, and you had people coming who had been planning their habitat banks for years and years and years. They'd secured their land, they'd got their HMP, they'd got their ecologist, they'd got their business plan, they'd got their financing, and they just needed the legal agreement. They wanted someone to sign on the dotted line. And for whatever reason, they may have approached the local authority, and some local authorities were really prepared for BNG and some struggled a bit in that area. And so there were delays, and people were saying, I just want, we're nearly there, we just want you to sign. So we had a lot of that at the beginning, and still there is quite a big logjam of people wanting to get their habitat bank. So that's been the focus, but it's certainly not what we want to focus on long term. We want to see conservation covenants used a lot wider. So yeah, we did a lot of reviewing our processes, along with noting what people needed. And actually, we said at the beginning, we're going to look at a 2-month time scale for doing this with our due diligence, and people were saying that's too long, we need it to be quicker, and we had to get more and more efficient. And cost was probably the biggest issue, because again, there wasn't a market, there was no one to set the bar against. We had to work out from the ground upwards, how many hours is this going to take us, our legal team, how many hours is it going to take our ecology team, how many monitoring visits do we think that we need per site, and what is the cost for that, and work it out like that. So yeah, we've definitely had to grow and adapt. So yeah, story so far, basically we started off quite small, and now we're a team of about 8 people specifically dealing with the responsible body. It says here we got the first conservation covenant for England. I can't actually verify that, because we certainly, I think, had the first one that was on the game site register, but I can't say that was the first one nationwide, because I don't have those that statistics. But we should have another 3 signed this week as well, so we're kind of trying to move them forward. So yeah, our policies and procedures, I'll talk a bit about our risk-based approach, because I think one of the biggest issues we found when talking to people, we had a lot of companies say, oh, we'd like to become a responsible body, but we're worried about having to enforce, and where's the money going to come from? And that was the biggest issue that I had when doing my business plan, to get across the kind of higher powers in Biocensus to say, actually, Defra are going to be relying on us to enforce these covenants. Enforcement is going, is a breach of contract. We have to enforce that in a civil procedure way, and that is an upfront cost. Even if you win your case, if it went all the way to court and you win your case, the court is going to reduce your cost slightly, inevitably. So there is a risk. There is a risk of having to put forward that cost. And how do you manage that? And one of the biggest ways of managing it is managing the risk at the beginning. So working very collaboratively with landowners and saying, before we enter into a covenant, we're going to look at your HMMP, we're going to look at your plans for land. Do we think you've got enough contingency measures? Have you planned for climate change? Have you done your soil samples? Have you planned for your, you've got a river running through? Have you planned for flooding? Or have you got enough, ulterior plans if something goes wrong so that these units don't fail? And making sure that it's a very high standard. And we have found actually the statutory HMMP really, really helpful for getting kind of uniformity across the board. That's been really good. And the metric actually really, really helpful to have consistency. That's been good. So we are requiring people to use those when they, whenever they can. So yeah, looking at a collaborative approach, and really the landowner benefits from that, because they get another team of good ecologists saying, let's review your plans and make sure that you have thought of everything. And we're seeing a range of standards, some people with incredibly brilliant documents coming through, and some that we have to go back and say, at this stage, we wouldn't enter into a covenant with you because you haven't considered everything. So that's the kind of the beginning process before we even give a cost, is to look at that and say, what, would we enter into a covenant with you based on your plan? And then if we would, this is an idea of the cost. And then there's a due diligence process where the ecological team will look into a bit more depth into your plans for the land. And then I will do a legal review with my team. So I will say, is there anything else that is on the land that's going to be a problem? Are there any other restrictive covenants or easements? You don't want to have your units and create this beautiful grassland, and then you realize that the electric company has an option on the land and they're just going to put a pipe down there in 5 years' time, and actually it might not be that pipeline itself destroys the habitat, but their access route. You've got to consider all these things to make sure that there is nothing on the land that is going to be in the way. So you do have to have the expertise in-house to be able to do that, to say, not necessarily in-house, you can obviously get people outside to do it, but it's expensive. But to say, have we investigated the title of the land, and are we sure that actually we can contract with you? So that's a kind of due diligence process that we go through. And then that forms the drafting of the covenant as well, like what flexibility do we need within the covenant? And really we want all the agreements to be adapted to suit the client. We want to be not saying this is the template that we're going to use and that's that. It's more, we want to facilitate the landowner doing what they want to do on the land, as long as it works. We want to make sure that it's a flexible agreement that works for the plan for the land, within the within the legal guidelines of B&G. So I will talk a little bit about enforcement. I know it's not everyone's favourite topic, and certainly hasn't been well, it's the one we've had the most questions about, really. I think the biggest boundary to people becoming a responsible body is this unknown element of how do we enforce. And I think that, we've got two, previously a litigation lawyer, we've got another litigation lawyer, and really we know that everything you can do to avoid litigation is always going to be best. So within our business plan, within our application process, and within our covenant, we've got our alternative dispute resolution process. Nobody wants to be going to court, nobody wants to be enforcing. No one ever comes out of court feeling like they've won, particularly in my experience. You want to be able to be really open and in open communication with the landowner at all times, to say, we're on hand to help. We've got a team of experts here to advise you whenever you need help. If something has gone wrong, what can we do to rectify it? How much time do you need? Are you in financial trouble? How many years do you need to put to get things back on track? Make sure there's flexibility, but also if there is a breach of covenant, can we negotiate? Can we have a couple of months of negotiation? Can we look at mediation? Can we look at alternative methods, so that actually you're managing the risk at all times of having to go to court? I did look at insurance for having to enforce a breach of covenant, and it's non-existent. No insurance company would say to me that they would insure proactive litigation, sadly. So you have to also work out in your business plan, how are you going to ring fence costs for that? It's an unlikely event that would happen, but you're entering into 30-year contracts with people. What if the landowner changes? You might have actually assessed the risk of this landowner. What if the land changes hands? Who's the subsequent landowner? You can't manage that risk as much. Do you have got ring-fenced pot of money to say this is what we would need for enforcement, and have you managed that, and have you planned for that? So definitely look at your alternative dispute resolution process in your application, I'd say is really helpful. Yeah, and a little bit back. So we started with B&G, lots of B&G because of the logjam. We're having a lot of questions about stacking, so stacking nutrient neutrality. And at the beginning, that was a bit of an unknown for us. We're looking at, we're looking to work hopefully with Natural England to say, how can we work to stack these? Because there has been a conservation covenant done for nutrient neutrality. So that's something that a lot of clients are asking about. But again, it's very much in the asking about it, but not necessarily having everything together like we've had with B&G. Likewise, flood alleviation, regenerative agriculture. But we've had also, that's not listed here, is farming clusters. We've had some consultants who have been working with different farmers, looking at doing kind of covenants for farming clusters. So we've had some really interesting discussions over the year about lots of different, like tree preservation we've had from one local authority that has been really fascinating. But again, it's very much asking about it. And I think one of the barriers again is that people are just a bit reluctant to be the new person to do it. And I think one of the comments I had from a company once was to say, oh, we really like the idea of conservation covenants, we just don't want to be the first one. And I think it's that. And I think, to be honest, as conservation covenants become very, very common with B&G, hopefully, because there will be standards that are then seen to be rolled out, there will be some kind of hopefully uniformity across how they're dealt with, that then they'll become a trusted document and a known document, so that other ways of using them will be explored. Equally, voluntary markets. We have had quite a lot of questions about voluntary B&G credits, and then again looking at how do we manage that and ensure there's no double counting. As the sort of regulator, you're wanting to ensure that your company has registers of what B&G units are sold and when and to who, so that there is no double counting. All these things to consider. I probably made it sound a bit complicated, and that wasn't really my intention, but I just say that the more thought you give it at the beginning in terms of how your processes are, what the risk management particularly is the biggest one, how you're going to manage enforcement. And I think then you'll have a good standing to say, actually, we're satisfied that really these are a safe thing to do, and that actually there's a really big market out there and there's a lot of demand. We have a backlog at the moment, which we're working through. We've had to increase the team, grow the team quite substantially over the last year. So there is a market out there, and we do need more responsible bodies. And different responsible bodies will bring different expertise. Like, wildlife trusts are going to come at it from a very different perspective than we are, which will be brilliant. And the idea of the responsible bodies kind of working together, I think, is a really good one to learn from each other, because everybody will have a different perspective. So yes, that's me done. And then any questions?
Thanks, Natalie. That's a fantastic presentation. I appreciate that. It's quite a bit that popped into my head in terms of questions. But what we'll do is we've got some Slido questions coming in. We'll answer those at some point, all of them, and we'll get back to people. But we'll try and cover some today as well. But first off, I thought I'd open up to the people on the call if they had any questions for Natalie on her presentation. I can't necessarily see everybody on my screen at once, so if I'm missing you, don't be shy, shout. But I can see James, you've got a question. Please fire away.
Hi, Natalie. That's absolutely fascinating. My question is, what happens in the highly unlikely event that the company is wound up, goes under as a financial disaster, and just gets just tanks, basically? I guess that could happen. Very unlikely, but it might do. Who would then enforce? Well,
it's really interesting. So you've got the risk of insolvency on both sides. So you've got the risk of insolvency from the landowner, in which case we want our conservation covenants to last, so that, especially for B&G, so the unit lasts, but particularly it's meant to be binding the land, really. It's the first time a positive obligation can bind the land legally. So you want it to pass to, if you've got an administrator in bankruptcy, they should then, own the land and hold the land in trust, and then it goes on to the next owner. And you want that conservation covenant to survive that process, if possible, to bind the subsequent owner. So the same thing kind of works for the responsible body. So if a responsible body goes under, then we've got a provision in our conservation covenant that we would then assign our conservation covenant to an alternative responsible body. And the law states that it has to go to another responsible body, and failing that, say there were no responsible bodies left, it would then be held by the Secretary of State.
Okay. Thanks.
Thanks, Natalie. That's helpful. I'll just add a little bit. We see it as very much as a last resort, because part of the role of responsible bodies would be to try to find another responsible body, includes in the title. And if the Secretary of State, as the responsible body of last resort, does step in, their responsibility is not to accept all the liabilities of that responsible body, but they will try and then move the covenant onto another responsible body. Yeah, they don't take on any liabilities. Thanks. I'm just looking who's next. I think Krista. I think you're next.
Yeah, thanks very much. And hi, Natalie. It's Krista Patrick here from Greater Manchester Combined Authority. We received responsible body status in December, and now we're kind of putting the detailed proposals and a kind of detailed options appraisal for our Combined Authority to review in terms of that. And some of the key issues that are coming up are around how do we manage liabilities and risk, but also the commercial side of things. I suppose it'd be interesting from yourself, how are you kind of looking at kind of addressing those kind of liabilities? I think you kind of referred to it, but particularly in terms of unforeseen kind of breaches, costs that are picked up there. Is it through some form of bond, indemnity, or something else? Obviously there are clauses that are set out in the conservation covenant that specify that, but again, there's only so much you can plan in terms of known knowns and known unknowns in terms of costs and what you can do from a commercial point of view, but there are going to be unknown things that come up. But also the other side of that then is, and this might get onto commercials that you're not able to kind of answer, but how do you make the kind of commercial case stack up? Because for us, in terms of kind of determining applications, we're going to have someone in post. Now, the upfront stuff of actually kind of going through and signing the conservation covenant and reviewing the proposals takes a certain amount of time. But when you then come on to intervals of monitoring, or carrying out the review of monitoring reports, which are over like 7 periods of time, throughout that kind of course of 30 years, that doesn't stack up in terms of actually kind of how do you kind of make that stack up to a person in post or a team in post? Because actually, unless you kind of have lots and lots of applications, that's going to be quite challenging. So just interested how you've kind of moved that and how you've made that all stack up.
Yeah, absolutely. I think that so we have a risk-based approach. When we have a client come to us and say, this is our proposal, we do an assessment of that client. So we'll do a credit check, an insolvency check, a general check about their reputation, make sure that they are somebody that we want to enter into a contract with, and also do the check of the HMP, and they get put on a level of risk. So we assign clients a level of risk from 1 to 4, and the basic lower level of risk, what we ask for is the payments for the monitoring over 30 years as an annual payment, but also you can look at other payment plans because they're a trustworthy client. And the monitoring goes down. So we monitor as a minimum every 5 years, simply because a breach of covenant is a civil breach, a breach of contract, and therefore you've got 6-year statute of limitations. So we try and monitor every 5 years. And if it looks like it's a riskier client or a riskier scheme, for example, then we put in more spot checks. So we have a minimum number of monitoring visits that we do over 30 years. And then we would add in, say, 1 or 2 spot checks, or 3 or 4, depending on the risk. And also the higher the client's risk, the more limited their payment options are. So ranging from having to put something into a bond to having to pay everything up front. And that's how we monitor it. So the lower the risk, the more payment options you have, essentially. And it's all dealt with on hourly rates. So how many visits do we need? What's the ecologist time for that? Is it half a day visit? Is it a big site? Is it a whole day visit? How far away is it? And all those go into our costing. Some things that were interesting on the leasehold front, because the leasehold doesn't automatically, if that is forfeit for any reason, doesn't automatically pass to the freeholder. for a leasehold client, we've asked for a bond to be set up to hold all the management fees and the monitoring fees. And then in our conservation covenant, we have a provision to say, if that lease is dissolved, because the freeholder isn't legally entitled, what happens is we invite the freeholder to re-enter into that covenant, in which case they would then get access to that bond. So we're not sort of the ultimate beneficiary. It then goes back to the freeholder to keep going with the management and maintenance as a kind of incentive. And then you've contracted, so you kind of re-raise the covenant and that unit survives. If in any way that doesn't happen, then that money has to go to securing alternative habitat, so it doesn't just go to us. So there's all these things that we've had to consider from a commercial perspective to manage our risk. Does that answer the question?
Yeah, thank you. I suppose it's just the other thing was just, actually then kind of managing that in terms of a team, because obviously, kind of if you've only got a handful of applications and there's only kind of, certain periods of time that you've got to go and kind of, review monitoring reports, that's quite challenging in terms of stacking up to a full-time role or a team. So it's just,
yeah,
quite
absolutely.
a challenge.
So yeah, and it is a bit of an unknown for any company. So I started on very part-time hours because the idea was that I wouldn't be needed very much, and then that's had to grow and expand the legal team. But we've certainly seen that there is a demand for enough of it. But again, I say you do need to consider if you have enough expertise in-house. But then there, you can look. We did get a lot of advice from external legal advisors at the beginning as well. That there's other advice that you can seek.
Thanks, Natalie. Thanks, Krista. We're running out of time a little bit. I can see 2 more questions. So maybe Angus, if you have a question, please fire away.
Hello, good morning. My name's
Hello,
Angus Hogg, planning solicitor, with taking a big interest in biodiversity net gain. So I'll try and ask a very quick question. Would you say that because we're approached by a lot of landowners who want to secure their BNG, so they're sort of shopping around a bit between local authorities and other responsible bodies, would you say Section 106 agreements and conservation covenants for BNG are almost the same? Or, I mean, your previous answer sounds as if there are a lot more sort of controls in a conservation covenant.
It's a really good question. I think, especially at the beginning, a lot of people were saying, well, what's the point in conservation covenants when you've got the Section 106 process working very well? And I'd say that it is a very good point, because conservation covenants weren't originally put in just for BNG. They were put in for a wide range of applications. You used to have these complicated processes for things like heritage assets, where you couldn't have the positive obligation run with the land, and you'd have to have funny leases and chargebacks and everything else. So they were for a wide range, and I think that they've slotted in very nicely for BNG at the moment, because there have been lockdowns with local authorities. There are subtle differences between them in that there are different enforcement methods. So I think because we're a private company as well, and we're looking at it from a risk-based perspective, I think that we're putting in, we're trying to hit a very high standard in terms of monitoring. So we're using all of our in-house expertise, which sometimes local authority don't have the kind of in-house ecologists. So I think for BNG, they can be definitely interchangeable. But I think that the benefit that you get from having a private company is that you get a lot more regular communication, you get regular reviews. If you want to, it's a bit more flexible. If you wanted to amend your HMMP, you can come to us and say, and we will review it and say, okay, how are we going to make this work for you? It's a lot more bespoke, I would say. We're looking at making these agreements really flexible for the landowner to facilitate them. It's very much, we are here to facilitate their plan. And I think that some local authorities might take that approach, and some local authorities might take the approach of, no, this is our this is what our standard precedent says, and you're not going outside it. But I think that there's also a wide range of expertise in local authorities and a wide range of costs. Some local authorities will not monitor much, and some will monitor a lot. So I think it really depends on what you as the landowner are looking for. Okay,
thank you.
Thanks, Natalie. We're over time by a couple of minutes, but we only have one question. So if we could deal with it within a minute, that'd be great. Is that Tim there with the question?
Yeah, it is. It's Tim. Thank you. I'm at North Yorkshire Council, a principal ecologist here. I've been working on BNG for a while. It's very reassuring, Natalie, to sort of to see you lay out the kind of level of diligence and checks that RSK is doing, and I hope that's representative of other RBs as they set themselves up. I think it's been frustrating from a local authority perspective how long it is taking to get through Section 106 agreements. You know, we desperately want to be able to facilitate and lubricate the market. I think one of the difficulties that we have that perhaps is not faced to the same degree by a commercial entity is that, you know, our finance people, our legal people are very cautious, you know, because we're a local government organisation. We have to, you know, make sure that we've checked everything and looked at every possible loophole and what are our step-in rights. Do we have an obligation to try and make sure the habitat is delivered if if the provider goes bust, or if the landowner is unable to do it. So the issue of bonds and whether we need to insist on one is a very hot topic at the moment, and I'm really struggling to sort of get through that. But I think it would be tremendously useful to sort of to kind of share knowledge and experience with organizations like RSK as to what that kind of financial and legal due diligence looks like. So
absolutely.
really reassuring to sort of hear what you're saying, and I think it would be incredibly valuable for lots of local authorities to understand that. So thank you very much.
You're welcome. Just a quick note before we finish on the notion of bonds, because what we are finding is that a lot of consultants and landowners, they are working at a deficit. You know, when we do the credit checks, they will fail the credit checks at the beginning, a lot of them, because what they've done is they've got a lot of upfront cost and they don't get any money back until they've sold a unit, but they can't sell a unit until they have their legal agreement. So it's, you know, you can't ask them to put all their money in a bond when they don't have any money as yet. So it's, what does that look like? And you need to really look at their business plan of how they're going to, you know, how much are they going to ring fence? And that all needs to then go into your agreement, essentially. And the same with step-in rights. Local authorities have automatic step-in rights for Section 106s. Responsible bodies don't. That needs to go in your agreement. So the legal agreement that we have is quite substantial, you know, looking at 35 pages long, because you have to consider all of these points. So it is a very good point, and this is why it took us quite a number of months to get to come up with all the processes that we have. But that's not to put people off. I think that when you do have those processes in place, and like you said, it would be good to share knowledge of it. Hopefully that will encourage other people to say, actually, this is something that has been very well thought through.
Thanks, Natalie, and I echo what you said about the degree of diligence in terms of RSK's approach. It's good to see and reassuring for us in Defra to see that. And just one more thing before we move on, and hopefully try and catch up a little bit of time. I'll mention it now. I was going to mention it at the end, but in case people dial off the call, what we're planning to do in Defra is to convene a responsible body group fairly soon, possibly within the next month or two, to bring the designated responsible bodies together and try to establish how we might share that best practice that you were talking about, Tim. So we're very keen to do that. And just to quickly answer one of the Slido questions, what we're also interested in doing and bringing the responsible bodies together is look for other opportunities in addition to BNG and other green marketplaces where covenants could be used and how we might incentivise them. So watch this space. We'll reach out to the responsible bodies to sort that out. We're a few minutes over, I can see, but thanks, Natalie, again for your presentation. We'll move on now. Can I ask David to give his presentation from Staffordshire Wildlife Trust? Dave's waiting. I'll just say, guys, I can see that there's lots of Slido questions and other questions. We'll prioritise the ones in the room, but we will, as I said, make sure we pick all of those up and make sure we respond to them all. So don't worry if we've missed your question. We will get back to you.
Morning all, I'm David Cadman from Staffordshire Wildlife Trust, currently head of Nature Recovery Networks, joined by my colleague Anna Nixon, who's our Ecological Projects Manager. So next slide, please, Jane. So yeah, as I said, David Cadman, Staffordshire Wildlife Trust, joined by my colleague Anna Nixon. So just a bit of background on sort of the organisation and our sort of purposes. So yes, we're currently Staffordshire's largest nature conservation charity, founded back in 1969, and we currently have approximately 130 staff, 20,000 members. And across the county, we've got 45 nature reserves that we manage, and sort of a whole variety of various conservation projects that we've undertaken, both with partners, local authorities, NGOs, etc., etc. So we're a component of the wildlife trusts. So currently 46 of those independent charities across England, Wales, Scotland, Northern Ireland, and we thought back in the day that that the sort of breadth of experience that we had as a wildlife trust sort of qualified us, internally at least, to look at that process as a responsible body. So can I have the next slide, please, Jane? Obviously, the sort of reason for our existence highlighted in the recent sort of State of Nature report about how the UK is one of the most nature depleted areas of the world, and 1 in 6 species are currently at risk of being lost from Great Britain. So we are obviously, as a charity, a wildlife charity, we are ultimately driven by our sort of aspirations around nature's recovery, particularly around 30 by 30. So obviously government and now UN target to look at protecting land, 30% of land by 2030. So we saw becoming responsible body, and initially the delivery of BNG as being a sort of a prime tool to help us achieve some of those aims. So as I say, as a wildlife trust, we've got significant experience in delivering, monitoring, undertaking conservation projects, restoration, monitoring. You say there's some award-winning projects there that we've undertaken, again, working with private landowners, Environment Agency, National Highways, etc., etc. And we've done an awful lot of ecological mapping, both for our local authorities, using data that we hold both as the Wildlife Trust and as Staffordshire Ecological Record, local biological record centre for the county. And what we wanted to see through BNG was this gold standard approach, that what was being delivered was actually being delivered, that it was the right habitat in the right place in Staffordshire to form that nature recovery network that you can see a draft sort of version of there in the slide, various habitats, performing this nature recovery network. So discussions internally were very much driven by that aspiration, that ambition to achieve and to contribute to nature's recovery. We've had lots and lots, as you could imagine, discussions internally as a charity about a lot of the issues that Natalie mentioned about enforcement and financial securities. We'll elaborate a little bit more as we go through the presentation. But ultimately, what has driven us is that we will undertake conservation covenants for landowners, for all sorts of organisations where it is obvious that we are prioritising nature's recovery. So through our due diligence process, where that isn't the primary sort of reason for engaging in the conservation covenant, to deliver that BNG, we know as a responsible body that we can walk away from that. So that's what's motivated us to move forward through the responsible body process. Next slide, please, Jane. So in terms of our application process, Gigi, environmental net gain manager, worked with us to put forward our application, which we initially submitted back in December 23. And so, as you would expect me to say, the team at Defra were really helpful in sort of getting our house in order, and we used that initial application form, and we provided lots and lots of information about our experience managing, again, large projects and the finances that go with that, and the accountability that go with that, monitoring of those reports and projects. So we've got quite a significant evidence base of our sort of conservation experience, and sort of the due diligence that we'd involved in that. One area where we did initially struggle was around the conflict of interest policy. So I think you can see on the timeline that we've laid out there that we had a number of goes at that. And again, Jane and her team were particularly helpful in sort of working that process through. Some of those issues we hadn't previously got policies on. I think a lot of our conflict of interest policies reflected sort of trustee input, trustee conflict of interest, et cetera, that weren't obviously necessarily specific to delivering conservation covenants. So we had a series of run-ups there, and again, we consulted colleagues within the Wildlife Trust movement on that. So we were quite happy with what we eventually ended up with, submitted that to Defra, and then we followed that up with an interview just to talk through those concerns, get that over the line, and then we, our 12-week clock commenced. And then, as you can see from the timeline, despite this slight interruption with the general election, we eventually got our designation over the line in towards the end of September. So during that process, sorry, next slide, please, Jane. So we internally have been working through a lot of those issues, and obviously, as Natalie referenced and others have questioned, that issue around enforcement, the due diligence, the fees, the investigating of sort of financial securities has been our sort of primary sort of area of work. And again, hands up, neither Anna, Gigi, or I have any legal training, so we are looking at external legal advice, which has been superb and has helped us again, and talking to other wildlife trusts about their experience. We've had terrific support from both our trustees and chief exec, that yes, we are mindful of those risks, but we are looking at how we manage those. I think we are happy with where we are at, and we are confident that we've got a number of cases that we're working through at the moment. So they will appear on the Defra register very soon for Staffordshire. But we're quite confident that the landowners we are working with, because of our history and knowledge, experience within the county, to some degree, part of our due diligence is knowing those landowners. And, talking again, to use BNG jargon, but, are those areas in areas of strategic significance? Are they helping, fill in the nature recovery network for Staffordshire? So that's all of those elements have been thrown in. And that's what we're continually working through. But ultimately, a lot of our risk procedures will be on a site-by-site basis, understanding that landowner, that habitat type, and those objectives very much is being worked out, on an individual basis. Next slide, please, Jane. So again, I'm talking about our risks and challenges. Obviously, as previously mentioned, as a charity, our primary purpose is around outcomes for nature. So that's what we're looking at. That's ultimately our reason for doing this. And as I say, we've had terrific support from our chief exec and trustees in what is, it's unknown territory, but we're working this through and working out our ways of doing that. As I say, the enforcement, we are talking to legal advice about how that is mitigated. And as I say, not a legal expert by any means. So sort of echoing a lot of the comments that Natalie made about how we will manage that. And for us, there is a huge issue around reputational risk. So we've done a lot of good work in the county, as have the trusts across the movement. We want to use that reputation to further our work, but also obviously very aware of the reputational risk that goes with potentially sites not quite coming off as we would have hoped. And the financial risk, yes, obviously we are a relatively small charity, so we're looking internally at about how we mitigate that. You know, we haven't necessarily got funds that are bankrolling us. We are looking at how we manage that. And again, similar to what Natalie mentioned about that sort of risk profile to each of the landowners, each of the sites that we're working with, we will be looking for financial securities and appropriate financial securities to ensure that we can, and they can, as a partnership, a collaboration, deliver that conservation covenant. So again, working with the team that we've got, primarily, we are obviously looking at the delivery of conservation covenants, prioritising BNG. But as Tim referenced, we certainly see opportunities to use the conservation covenants far wider than just BNG. We are a live issue. We are looking at how we can use them for cultural heritage, uniting the sort of biological and the cultural, the historical. We've got sites that share both biological, cultural, historical interest. How can we bring all of those issues together? And a cultural heritage officer is looking at working with some historical consultancies to sort of use those conservation covenants to reflect those levels of interest, and also going forward, clearly carbon could be something we factor in as well as water quality issues. So there's quite a lot to be contending with at the moment. We're a relatively small team, but I think what we're bolstered by is that we are part of a much bigger movement of trusts, and we're quite keen that we and the other trusts work to capitalise on the opportunities that we have here. So we are hoping that there will be more of a Wildlife Trust wide movement towards responsible bodies and delivering gold-plated, in the first instance, gold-plated biodiversity net gain towards 30 by 30 in nature's recovery. So thank you very much. That's my whistle stop.
Thanks, Dave. Thank you very much. That's really interesting to get your perspective from a wildlife trust. We'll open up the floor to questions, and I can see Jennifer, you're the first one with your hand up, so far away.
I just had a question. You mentioned that you're being quite selective on who you engage with in setting up conservation covenants because you're prioritising nature recovery. Also, that you're being having to be quite diligent about financial security. Do you sort of set out those criteria in some kind of prospectus, or do you discuss that at a later stage? And how do you demonstrate that you've got some kind of transparency on how you're selecting who you work with?
We are working towards having that, essentially that prospectus of what our aims and objectives are. We haven't got that currently, but that's something we are working towards, so that there is some transparency there.
Thanks, Dave. Does that help, Jennifer?
Yes, thanks. That's useful. I'll look forward to hopefully seeing that at some point.
I can't see any other questions popping up, but shout if I'm missing you. I'll just pop a quick question to you, Dave, and to Natalie, actually, if you're still there, Natalie. One of the things in the early days of thinking about covenants was how sort of landowners would perceive them. And in your work with landowners so far, have there been particular concerns or barriers to getting them on board for delivering covenants? What kind of concerns have landowners had?
Yeah, that's probably one for Natalie, yeah.
Yeah, so to be honest, because most of the landowners that we have had over the last year have been really pushing to get their habitat bank secure or to get their units, it's more the opposite way around. It's more been seen as like this is an answer to prayer because they're finally able to get this thing created. And also, the landowners that we've dealt with have also had very good legal teams, and then the legal team they've been dealing with has often been dealing with Section 106s and planning, so they're used to dealing with this kind of contract. So we haven't really had any barriers in terms of their nervousness in looking into a conservation covenant. I think for a lot of landowners who don't have a legal background, the notion of a conservation covenant is just as alien as a Section 106 agreement in a way. So, either one of them would be, oh, this is completely new, and how do I deal with it? And then their legal team is going to help them through that.
No, that's great. That's interesting, because in our early thinking, we thought landowners might be reluctant, but I think there's probably a group of landowners who are far from reluctant.
Yes.
Yeah, and it's not a case of persuading them; it's a case of managing the demand, which is probably a good thing. Any thoughts from you on that, Dave? Or?
No, it hasn't really been an issue to date.
Oh, great. Oh, and great, Julian, you've got a question. Please fire away for Dave.
Yeah, thank you. I guess I'm probably just piggybacking on your question actually there, Tim, but I was just wondering where there isn't a requirement involved or the kind of a commercial interest. So if you've got more of a maybe altruistic landowner, are there challenges in that context that there are, that there has to be funding sourced from somewhere to make these things work?
And I guess that's a question to everyone, really, Julian, isn't it? I think yes. For altruistic landowners, the incentive is securing the nature recovery, and then how you derive funding to do that in the long term is interesting. And I think that leads me to a sort of follow-up question, unless Dave and Natalie wanted to come back on that as well. Is the model that appears to be emerging in some cases is that third-party investors are becoming interested. And I wondered, possibly for you, Natalie, more than Dave, but for those where you've worked, I think you may have worked with some third-party investors, where that's the case. Again, what are the opportunities, obviously commercial, I guess, they're seeing, and what are the barriers, and how could we incentivize more third-party investment into covenants?
Yeah, we are seeing a lot of consultants who are. We're seeing a lot of consultants who are then getting investment in to start a project, and then they are acting as the broker between the landowner and the buyer for the units. Particularly with B&G, we're seeing consultants working with a lot of landowners all over the country, and that's quite handy because then they've got a central legal team. We can have a standard precedent we use. It means that the costs go down because we're not redoing a covenant every single time. But I think that one of the frustrating things we've certainly come across is the fact that a conservation covenant doesn't automatically pass from a leaseholder to a freeholder. So these consultants are coming saying, and why do you have to, we're the ones taking on the risk. We're the ones with the ecology team. We're the ones managing the land. Why do you have to contract with the landowner? And we're saying, because legally we have to contract with the landowner. And if you don't have a lease, we have to contract with the landowner. If you do have a lease, it becomes quite complicated, and we would need a bond to manage the risk. And if the law changed so that, on the extinguishment of the lease, it passed to a freeholder, I think that would actually make it a lot easier, because then you would be able to contract into these agreements with the consultants themselves, and they would be happy with that. The landowners themselves would be happy with that, because they would see the burden and the risk being taken on by the consultant who is managing everything. But that would require a bit of a legal upheaval.
Yeah, yes, I think it would. And is that even possible at the moment then, Natalie? I don't think it is it? Or is it?
No, I think that it would require a change in the law.
Yeah, I thought so. Yeah. That's something we might pick up on then and have a think about. If we were to form a sort of an informal group, it might be quite interesting to explore a little bit. And sort of vaguely related to that, I noticed a question in the chat from Janet around the relationship between local nature recovery strategies and support the growth covenants. It's a very good question, Janet, and one we've just started to think about a little bit. Because obviously ideally we would want to incentivize the use of those covenants to secure what's in the strategy in the long term. So we're having a think about that in Defra, and that's again something that we might want to come back to if we were to form a sort of responsible body group. For those of you who perhaps who aren't thinking of applying or in the process of applying, by all means stay on the call. But if not, this will be not a technical session, but a detailed session about the completing the application form, just to let you know. So is it over to you, Jane?
Hello, I'm Jane Widowson. I'm the policy lead on conservation covenants, and we wanted to talk you through how to make sure that an application to become a responsible body is complete. So that really avoids the need for us to sort of go back to applicants to request further evidence or information, and obviously speeds up the process for everyone. So just a few general points on the application and the assessment process to begin with. It's a rolling process, there's no deadline, and all applications are assessed against the 4 published criteria that are available on gov.uk. And a broad range of applications of organisations, can apply. So public bodies, local authorities, charities, private companies, and all applications are assessed in the same way. They're treated the same, irrespective of the type of organisation applying. There's only one element really where that doesn't apply. Under the Environment Act, local authorities aren't required to provide evidence of their conservation purpose, but otherwise all applications are treated the same. Obviously, we've learnt lessons as a team through assessing the applications we've received so far. We have already, I think it's been referred to earlier, but we have already updated the application form to try and help explain the types of evidence we're looking for. And before we talk through each criteria, just more generally, we've found that we've needed to request more information from applicants where they've provided perhaps broad statements, sort of saying that the organisation has, let's say, the necessary expertise or a particular policy or process, but without providing any evidence of that or any supporting documentation. And also, we've probably needed to request more information where evidence just in general is lacking in detail or where it's not necessarily relevant to the specific criteria. But just to say, before we go on to talk through the evidence for each criteria, obviously providing the types of evidence we're going to give examples of doesn't in itself guarantee designation as a responsible body. It's to help us have complete applications, but the process actually involves quite a thorough assessment. So this is more, to help ensure applications are complete. So the first criterion is eligibility. And as part of that, we ask for evidence of a UK operating base where the main activities and people delivering covenants would be based. So complete evidence for this criterion would be things like a copy of your most recent business rates bill at a UK address or recent utility bills, or depending on the type of organisation that's supplying, if it's relevant, then the UK base being registered on Companies House or the Charity Commission website. But this elements or evidence that might mean we need to go back to an applicant would be things like outdated documents or, say, only providing a PO box address. And then the other main element of the eligibility criteria is evidence of a conservation purpose, function or activity. That does depend under the Environment Act on the type of organisation applying. But again, complete evidence for this would be things like relevant sections of reports summarising conservation projects you've delivered, your most recent annual report, if that's available, charitable objects, if you're a charity, or copies of conservation management plans. Again, evidence that's probably we'd consider more incomplete and we might need to request further information on would be things like broad statements just setting out conservation purpose or function but that are without evidence or supporting documentation alongside that. And then just moving on to the second criterion, so that's financial security. The main evidence we look for here, alongside details of a UK bank account, is a complete year's financial statement for the latest financial year. That they would ideally be audited, although we know, depending on different circumstances, that's not necessarily always possible or relevant. But also, if you're a local authority, then that could also be a statutory report for the last financial year under Section 25 of the Local Government Finance Act. And just to add here, the application form does ask all local authorities to confirm if any Section 114 report has been issued. And then if you're a newly formed organisation that might not have a complete year's financial statements, then a set of current management accounts, so that would be profit and loss or income and expenditure, along with a balance sheet, would be considered sort of complete evidence. Evidence that might be considered incomplete on this element would be financial statements that aren't from the most recent financial year. We'd probably come back and ask for the latest statements when they're available. Management accounts that aren't a full set, so that don't include that profit or loss and income expenditure along with a balance sheet, or more forward-looking financial plans or projections. And then the other evidence of financial security that we're looking for is of suitably qualified staff that are accountable for fiscal control, particularly given the long-term nature of conservation covenants. So complete evidence here would be an organisational chart that clearly shows staff that are accountable for fiscal control. Again, where relevant, evidence that your filing of accounts is up to date on Companies House or with the Charity Commission is useful, because we use Spotlight, which is a Cabinet Office automated due diligence tool that sort of captures information from a range of sources. So that's always useful. And then we ask everyone for a financial declaration signed by an accountant, finance director or equivalent, whose details can be verified, usually online. So for this element, evidence that might be considered incomplete would be organisational charts, obviously, that don't really show any suitably qualified staff, or a financial declaration that's been signed by someone in a non-finance role or whose details can't be verified. And just to say, before I hand over to my colleague Sarah, I get this might be a bit of a sort of a whistle-stop tour, so we will be sharing the slides, and we're always open to questions on particular elements of applications. But I'll pause there and hand over to my colleague Sarah, who's going to talk through evidence for the remaining criteria. So I'll move the first slide on, Sarah, and I'll hand over to you there.
Thank you, Jane. So here for our third criterion, which tests the organisation's operational capacity and capability to become a responsible body. It's the longest criteria, as applicants have to provide a wide range of evidence for different elements, which I'll go through now. But just to preface, as Jane has said, this is part of criterion 1 to 4. So this would be what makes an application complete versus incomplete, where we'd usually go back to applicants and ask for further information. And then once as the policy team deem an application complete, that quality of evidence is then assessed and then finally decided on by our panel, responsible body panel. So here for expertise, we have what we consider complete would be details or CVs of key people within your organisation, which include skills, experience, qualifications in ecology or nature conservation, or heritage if you've also applied to do heritage covenants. And we also need access to, we need details of your access to external experts if your organisation does not have any in-house ecology expertise. What we would consider incomplete is if an applicant has generally provided broad statements that you have expertise with no specific reference to people within your organisation or external expertise. Also, any CVs that are unrelated to ecology or conservation. That could be, for example, green sustainability or data science, legal or finance. We want to see ecology and conservation expertise and skills. So for workforce structure and capacity to deliver covenants, complete would be organisations providing an organisation chart, which clearly shows who will be delivering, managing and administering covenants. And also to support that, a brief summary explaining how you'll work collaboratively with landowners and who will be involved in the monitoring and evaluation of covenants. It's also important to remember, if you've applied for heritage covenants, that you provide some more detail on how heritage covenants will be carried out and how you will reuse your resources or what resources will be used. And any incomplete evidence would be a general organisation chart that's not really specific or relevant to covenants, and limited detail or no summary of how your teams will work collaboratively with landowners and who will be involved in the monitoring and evaluation. Yeah, next slide, please, Jane. So for contingency planning, complete evidence would be a complete risk register or assessment, which has detailed mitigation actions in place. This could be for previous projects that you've done, or it could be developed specifically for conservation covenants. Or you could also provide a risk assessment policy or contingency arrangement plan that for your organisation as a whole. Incomplete evidence for this would be a blank risk register template, because we're unable to assess your risk capability this way. Also, with a risk register, if there's any limited or there's no detail of your mitigation actions in place for individual risks, that would be incomplete. And as we've said, broad statements of experience in monitoring risk or conducting risk assessments. So that's where we'd go back and ask for more information. So we've got monitoring and compliance and addressing breaches of agreement by a landowner. So complete evidence for this element would be a copy of any monitoring and compliance reports or arrangements that you've used for previous projects, or you could provide any developed specifically for conservation covenants. That would also be helpful. We also need to see a copy of an enforcement process, or if you could set out an enforcement approach detailing how you would take action to address a breach of agreement by a landowner if that were to happen. And any incomplete evidence would be broad statements saying that you have experience of addressing breaches, as you've said. And then for track record, we've got how you would resolve disputes with a landowner, which is a potential problem that could happen in a covenant. So for complete evidence for this would be a copy of a dispute resolution plan or a process used for previous projects, and or developing a process resolving disputes specifically for conservation covenants. We would also need to see details or summary of access to an adjudicator, professional mediation or arbitration services that your organisation has access to and would use in the event of a dispute. And any incomplete evidence would be broad statements of experience saying that you are able to handle disputes or that you have lawyers to manage dispute resolution. And if there was limited detail of your access to an adjudicator or professional mediation or arbitration services. Next slide, please, Jane. So for this element, Defra checks that your organisation has clear structures and governance in place to report and escalate any issues. And this also includes a part to identify, mitigate and escalate conflicts of interest. So for this element, we found that we've had to go back to a number of organisations just because it's quite a new, being a responsible body is quite new, so they might not have thought about all these different conflicts that might happen. So for complete evidence for this would be a summary which clearly explains your governance structure and your reporting lines for any issues. And if you could also include a copy of your organisation's governance chart, that's also very helpful. for the conflicts of interest part of this question, it's really helpful for organisations to think about how conflicts would play out in their role as a responsible body. So in many cases, organisations do have to go away and develop a new policy or process to provide the evidence needed, as they may not have this already, obviously due to being a responsible body is quite a new tool. So complete evidence for this would be applicants providing a clear process setting out how it would identify and address conflicts of interest at the organisational level. Who would identify these conflicts and what would their process be for considering or mitigating these conflicts? And also how they would be escalated through your organisation's specific governance structure. So this policy in particular, when thinking about developing one, it could include examples of actual or perceived conflicts. For example, acting as a responsible body for land that your organisation has interest in. And it could go as far as to mean organisational conflicts or activities or services that you provide that might come into conflict with your responsible body role when entering into a conservation covenant. So it really involves that sort of thinking about what different conflicts could arise from being a responsible body and also offering other services or having other functions within your organisation. It's also helpful for organisations to provide a flowchart or a diagram setting out how it would identify, mitigate and escalate these conflicts. And then for this, incomplete evidence would be broad statements about your governance structure without details of key people or roles involved in the process. Any general conflict of interest policy that's not related to acting as a responsible body. So for example, typically we've seen conflict of interest policies at the level of individuals, which include financial or loyalty-based conflicts, which doesn't really address organisational level conflicts. And then also any copies of conflict of interest disclosure forms or a conflict of interest employee register. So yeah, it's really important to make that distinction between the two kinds of conflicts. Next slide, please, Jane. And then we have, for the final part of this criterion, operational capacity and capability, we have track record. So this is track record in successfully managing conservation projects. So complete evidence for this would be a summary of experience, your organisation's experience, successfully managing conservation and heritage projects if you've applied to do heritage. Copies of any project reports, how you've worked collaboratively with landowners and how you've achieved successful outcomes for the environment. And for newly established organisations, if you could provide a summary of conservation projects or heritage projects carried out by individuals within your organisation and how you've worked collaboratively with landowners. Incomplete evidence for track record would be limited evidence, so limited summary of experience and lack of specific details. So not including where the project took place, any sort of metrics, what the aims and the outcomes were. Limited detail of working with landowners to achieve successful outcomes as well. Lack of reference to any project reports that we can verify, and for new established organisations, no conservation or heritage projects carried out by individuals, or limited detail of working collaboratively with landowners. And then for the last criteria, criterion 4, which is our ongoing suitability criteria, it's where we kind of we require applicants to sign an operational assurance declaration at the end of the application. And this is to ensure us that they understand the role and the responsibilities involved in being a responsible body. And it requires them to commit to informing the Secretary of State if their circumstances change within the organisation. That means it can't carry out its conservation covenants that is entered into. So yeah, that's a roundoff from me about just the process in a whole and what it takes to make an application as complete as possible so that we can assess it and make a recommendation to panel members.
Thanks, Sarah, and thanks, Jane. That's a whistle-stop run through which is quite a process, really. And underpinning that is the need to make sure that responsible bodies are indeed going to be responsible in the long term. Let's quickly open up to questions. Please fire away if you've got any questions. If we don't get to you, please do put the question in Slido and we'll come back to you in slightly longer time. I think, Jack, you're the first.
Thanks. Can you hear me okay?
Yes, we can, Jack. Thank you.
Yeah, it was just a quick question regarding the conflict of interest. So how is the integrity of the BNG system sort of secured when habitat bank owners or managers are allowed to become their own responsible bodies?
You cannot be a responsible body for the land that you own. And I think that's one of the points local authorities have struggled with, is that if they're creating habitat banks in their own land, they cannot become a responsible body for land that they own. So they have to consider other ways of doing that by forming SPVs and different companies. So habitat banks themselves cannot be a responsible body for the habitat banks that they run, because it would be a conflict. And likewise, with our company, we had to consider it because RSK as a whole owns a number of companies. So we've got RSK Environment, RSK Nature Repair, other things. And we have to be really careful that we're not being a responsible body for anybody else that RSK are then working with in a way that would cause a conflict. So that's why habitat banks have to have a separate responsible body. And we have seen some local authorities buddy up with other local authorities to become responsible bodies for the alternative, so that they can both do it that way. So there's other ways of managing it.
Thanks, Natalie. And we're aware, Jack, that one of the hopes and expectations we have is, as we get more responsible bodies, local authorities will be able to look to other local authorities in their area to do exactly what Natalie described and work together so that they can form covenants on their land. But obviously we need more applications from local authorities. So if you're a local authority and there are any barriers stopping you applying, do let us know. We will try and work through those with you. Any other questions? Good. We're coming to the last minute of the scheduled session, so feel free to pop any other questions about the process or indeed anything else that's covered in the session into Slido. If we go on to the very last slide, I think, Jane, there's some contact details there. So feel free to use that email address at the bottom. Let us know. And the other thing, in addition to just thanking all those who presented today, is to say, as I mentioned earlier, we will be trying to establish a sort of working group with the responsible bodies fairly soon. The other quick question before we sign off is we're also expecting to probably run a few more sessions like this. Could you just put a bit of a thumbs up if you found today useful and other sessions would be helpful? I'm getting quite a few thumbs. That's great. Thank you. In light of that, again, using that email address there, if there are particular things you'd like us to focus on when we bring responsible bodies and local authorities together, then please do let us know and we'll be happy to try and pick those up. Thanks again to Zane and PAS. Otherwise, have a good day, everybody. And as I said, we will respond to all the questions in due course. We'll try and get back to those as quickly as we can. Thanks very much, everybody. Have a good day.
Thank you.
Thank you.
Thanks everyone.
Thank you. Bye.